Justice Jackson?
Yes, I have two questions, one concrete and one big picture. The concrete question comes from a statement that you make in your reply brief about MOHELA standing to earn offsetting fees. Can you spell out what those and by that I mean offsetting fees from the discharges so that we aren't even really sure, what the net loss would be? Can you spell out a little bit more about those?
Yes. So under the department's contracts with MOHELA, MOHELA receives fees for discharging accounts. And we were making the point that here, Missouri hasn't come forward with any allegations that MOHELA will actually, sum total, suffer financial injury under this plan. This is all just in service of making the broader point that any financial effects downstream on the state here are attenuated and speculative.
So we don't know really what the ultimate loss would be to MOHELA, even if we believe that MOHELA is part of the state.
That's right. The states haven't offered any evidence in that regard to substantiate their assertion of standing.
All right. And I also have a big picture question about standing. You've been arguing that standing here would be a reach if we were to, for example, find that, MOHELA somehow losses to it count for the purpose of the state based on established standing principles. And what I've been mulling and wondering is whether the same concerns about the political significance of this case that the chief pointed to could be a reason for us to hold the line in terms of thinking about our standing doctrine and whether or not we should expand it in this area. I understood that the standing bar really as applied in a case like this, would allow the political branches to hash this out without interference, from a torrent of lawsuits brought by states and entities and individuals who don't have a real personal stake in the outcome. And in some ways, it's not unlike a case we heard last week where people were very concerned about lawsuits against tech companies and how they might hobble these companies if we allowed them to go forward. And I guess I have that same worry about the operation of the federal government and its ability to govern if we look at our standing doctrine in cases like this and we find that, even the most minor state interest, a dormant fund that hasn't been funded or used by the state in 15 years, if that can be the basis for standing, I guess I'm concerned that we're going to have a problem in terms of the federal government's ability to operate. So my question is this a legitimate concern, and should we be thinking in cases like this about that type of concern as we ponder whether to expand our standing doctrines?
I think it is a legitimate concern. The court has never suggested before that it should alter ordinary Article III principles and allow plaintiffs to sue based on concerns about the significance of the action. And in fact, the court has said again and again that the fact that no one might have standing to sue about an action doesn't mean that you should alter Article III and allow a suit to proceed, because the judiciary doesn't sit as a roving commission to rule on the legality of either Congress's enactments or the executive's implementation of those enactments. But I think it would be particularly anomalous in this case to accept any of the state's attenuated theories of standing, because there isn't even a situation where there's no other identifiable plaintiff or possibility to have the courts weigh in on these issues. The problem here is that the states aren't the proper plaintiff to bring this suit.
Thank you.